Let's get right into it. Let's get started. So the idea of this panel is first and foremost a stock-taking exercise. We've already heard from our great keynote speakers about both the necessity and added value of cross-regulatory cooperation. But the idea of this panel is to dig a little bit deeper by hearing some first-hand accounts and perspectives on what cross-regulatory cooperation looks like today, both at the national, European, and international level. Now, those of you who have been following this space will no doubt be familiar with the landmark judgment of the European Court of Justice in Bundeskartellamt, which was following a case initiated by the German Competition Authority against Meta, in which the CGU confirmed two very important things. The first is the possibility for competition authorities to consider, as part of their assessment of a possible abuse of dominance, compliance with data protection rules where this analysis is necessary to establish the existence of such an abuse. But perhaps even more importantly, it confirmed the duty of sincere cooperation among competition authorities and data protection authorities when implementing and applying EU law. And with this background, I would like to start by asking my first question to Mr. Lasserre. Last year, the CNIL published a report with the conclusions of your mission to analyze the interplay between competition and data protection law. What were your main findings? Are there things other jurisdictions can learn from the ongoing cooperation between authorities for competition and data protection in France?
Thank you. I don't know if it works. Yes, thank you very much. I'm very happy to be here. And thank you for the EDPS invitation. Well, to answer your question, in France, not everything, but there have been two important elements in 2023. The first one was the publication in December of a joint declaration made by both chairs of the CNIL on one side and the competition authority on the other side, showing their willingness to better coordinate their actions at the highest level. And 6 months earlier, Brendan, you mentioned it, the Meta judgment by the European Court of Justice provided a legal framework to organize and to encourage this loyal cooperation between the two agencies. So I was asked to make proposals to organize concretely this cooperation. But when we mean better cooperation, what do we mean? That were the questions I had to answer. The first question is the link between data protection and competition one-sided or is it reciprocal? Of course, the answer is reciprocal, and the answer is the content of the Meta judgment. On one side, of course, market power derives in many cases, especially in digital economy, from the power to collect and use huge amounts of personal data, and remedies, sometimes completed by competition agencies, in fact, are built on, are data related, I would say. And on the second side, and it's not obvious, of course, data protection, privacy is a fundamental right, but in fact, de facto, it is an economic regulation because the data protection agency, in fact, orients the markets. Sometimes implicitly, without knowing it or having conscience of it. For example, when they design remedies, when they make recommendations, in fact, they shape business model or the influence business models are shaped or built or influence the way competition can function in such or such market. So, first question, reciprocity, yes. The second question was about how this cooperation can be broad. Does it embark only competition and data protection agencies, or should we embark, and the, of course, British example is very telling, financial services, consumer protection, media, and telecom, and so on. So this question was beyond my mandate, because in France we have a sort of forum, but which is more focused on public policy than pure regulatory matters. And we have what we call the PEREN, which is a fantastic experience of sharing expertise and making mutual studies for the different regulatory agencies. So the question was beyond my mandate. So the real question was, when we talk about better cooperation, do we talk only about cases of conflicting norms, or should we base that cooperation on an integrated vision and dialogue between the legal frameworks, between the concepts themselves, the doctrines made by each regulatory agency, and the tools they use in doing, for example, cases or strategic analysis. And starting from that point, I advocated for that kind of, I would say, cultural hybridization of the two sets of regulation. Exactly, I would share the same words of Kate Jones and Alexander Destrel a few minutes ago. That's a question of culture, that's a question of practical tips to create in each agency the envy to learn from the others and to understand the concepts which are used by the others. So it's a sort of cultural assimilation in a game which is not a zero-sum game, but just on the contrary, a game where every agency has to gain from the other in incorporating analyses made by the other. And I take two examples. So I made 15 proposals to make the cooperation more fluid, more rapid, more natural, I would say, but I invite you to read that report, which has been published in French and in English on the CNIL website. I have no time to develop, but I would take two examples on how it illustrates the common benefits of that cooperation. A case dealt by the CNIL and a case dealt by the competition agency. The case dealt by the CNIL was the recommendation issued last year on mobile applications. The CNIL wanted to help professionals to design, I would say, and the users, to design, in fact, data protection friendly, privacy friendly frameworks on mobile applications, which are used daily by everyone. And in that respect, it took the advice of the competition agency, and the competition agency made recommendations in order to incorporate in the recommendation by the CNIL some ideas, especially on what you call permission systems, the way a user gives its technical permission to block or to access information, for example, geolocation, microphone, camera, and so on. And these proposals have been incorporated in the CNIL final product. And I think it proved that we can deliver both competition-friendly and data protection-friendly products which give legal certainty to businesses and which help users to understand practically the benefits of the two regulations. The other case is the case decided by the competition agency last year as well, the Apple AT&T case, app tracking transparency. And the case is interesting because it's a case about the interplay between GDPR and competition law, but not in the same way the meta judgment intervened, where we had the case of, how do you collect user consent, for example, for different services. In that case, nobody put into question the willingness of Apple to have a framework which respects GDPR and which respects the need to collect the consent of the user. The problem was in the way this framework was implemented by Apple. In fact, it was disproportionate in the way it made the content for the third-party applications more difficult to give. And in fact, it discouraged, or in fact, was not neutral in the detriment of small publishers financed by advertising. And that's interesting because in that case, the competition agency referred the case to the CNIL to get its advice, and at the end, to invite Apple to modify its framework, in fact, invited Apple to interact with the CNIL. And in that two cases, we see in very practical ways how, a better decision can be taken when we dialogue and we take into account the point of view of the other agency. We didn't choose in France the system in the British of institutionalizing this cooperation, but more, I would say, a sort of hybridization, a cultural integration, and this way by training, by frameworks, by working together on cases, by creating this hybridization, I find very productive.
Thank you very much, Mr. Lasserre, both for those practical examples. And I liked very much what you said about cultural integration and practical cooperation. And with that, I would like to turn to Mrs. Renate Nikolay from the European Commission to get a better sense of what integration and cooperation looks like within the European Commission. As the European Commission, as many of you are quite familiar, has gained several new enforcement competences under the new Digital Rulebook, under the Digital Markets Act, Digital Services Act, and AI Act, and there are already several touch points among those instruments alone. So my question to you, Ms. Nikolay, is what does coordination across Commission services look like in this respect, and have you identified any specific areas where further coordination will be needed?
Yeah, thank you very much. And this is really an interesting moment to talk about that, because indeed with the development of the digital kind of landscape and the digital rule book being quite expanded, you see that there are a lot of kind of different pieces that speak to each other. And if we kind of treat them in silo kind of, mentality, we will never reach the full impact. And we will certainly also make mistakes. So you mentioned kind of the DSA, the DMA, the AI Act, as examples. I think, just to give you a little bit of an impression on where we are in the Commission, and then of course there's another dimension to how we interact with the national kind of, aspects on this. We haven't institutionalized it in the sense that, was kind of referred to, but de facto, ad hoc, we are actually kind of developing quite good kind of, reflexes to touch points, to interact with each other in a systemic way. Sometimes this is kind of built in. If you take the DMA, for instance, this is not only dealt with by one Directorate General, this is a cooperation already by two, because it's a joint work between DG Competition and DG CONNECT. Maybe in the long term, not the most efficient kind of approach to it, but I think especially in the kind of the building up phase of getting into the enforcement habitus of kind of the DMA, if you take into account where we come from, DG CONNECT comes from a very different kind of angle into the regulatory rule book than DG Competition from the kind of competition angle. That has proven in the kind of in the first phase of applying the DMA to the gatekeepers very useful. The read across to antitrust, the read across to AI developments and the AI Act, I think was nurtured by the fact that we are working on this in joint teams, joint case teams, of course, between these two Directorate Generals. But then, of course, to give you another example, we have within DG CONNECT these various pieces. We have the DSA, we have the AI Act, we even have the European Media Freedom Act, also a kind of an important addition to the digital rule book. And here it was extremely necessary to kind of, do the read acrosses throughout the development even of the laws. So the AI Act came after the DSA, so had to be, of course, influenced by the experience of the DSA. The EMFA, the European Media Freedom Act, built in a way on the DSA, especially when it comes to the platform economy aspects of the EMFA. And nothing of that would have been possible without an upstream kind of involvement already. Now that the acts are there, how we kind of apply this in an effective way, I kind of facilitate in my role as a senior manager a lot of kind of cross directorates, cross kind of offices, cooperation. I give you an example. Minor protection online has been an important focal point of our enforcement activities on the DSA. But you cannot kind of, do a proper enforcement strategy on, minor protection online if you don't kind of read it across with the GDPR, if you don't read it across with the Audiovisual Services Directive that is there, and also even the consumer acquis, which is relevant here. So, I think what I see also in this commission, which is driven by a simplification agenda, which requires us to, before we come with an initiative and say, oh, wouldn't it be great for this commissioner to come with a new initiative on consumer law or on minor protection law, that we actually kind of build first on what already exists. It's a really different discipline that is being applied in the Commission to really kind of look around and kind of map the regulatory landscape and have that built into the better regulation angle before we develop that. And then also when you define that you can come with a regulatory intervention, for instance, then you do it in a smart way and you build on substances that are already there. You build even on structures that are already there in order to avoid unnecessary duplication, unnecessary new kind of, clubs to be created. If you compare that with the kind of the past 10 years, I would say, being a bit self-critical also, we have created plenty of boards and structures, maybe too many, that need to talk to each other. And I think we facilitate that at the moment, but certainly for the future, it would be useful to synchronize this even more and kind of avoid even more duplications. So I think we are experimenting with this, having kind of joined up kind of, work streams, but, both for the European level and for the national level. In the past, we created too much of the silos that we now try to recuperate. However, to bring in now, if I may, still also the national level, because what I see in my work, for instance, on the DSA, and John is with me on the panel, so it's a good moment. To give you an example, yesterday we launched an investigation regarding CROC. And this is a good example where this is not only an investigation that we lead as the European Commission in charge of the very large online platforms alone. No, we do this in concert with Commissioner Meán, because country of establishment kind of, digital service coordinator for X, but also with a lot of expertise, a lot of kind of, potential impact in our investigation. So this is a very new model that is built into the DSA, that you can actually effectively, even on cases, work together with individual, data protection, digital service coordinators. And I think what we are also seeing is that this potential of gathering on such a fundamental kind of digital rule book, such as the DSA or the DMA, you need the expertise from the others. That's why in the DMA, for instance, the high-level group has been a very important, basis to gather expertise around the table. How could we kind of be useful in enforcing well Article 5.2 of the DMA, which has clearly a kind of a data protection context, without bringing in the expertise of the data protection kind of authorities? How could we, on the DSA side, kind of really do kind of well on defining guidelines on Article 28 on minor protection online, without bringing in the expertise of plenty of kind of, structures around us? This has led even to the creation of memorandum of understanding that we have built within the Commission between different services. I mean, we have, for instance, one with JUST, obviously, because of the data protection angle, because of the rights of the child angle, because of their expertise on the code of conduct and illegal hate speech, but also with HOME, because of the CSAM aspect, so the child sexual abuse material, because of the terrorist content online aspect. And I've never seen that before. So there's a huge willingness, because if you have an MOU Why do we go that kind of, so it's a little bit more than the ad hoc reflex. It's already almost institutionalizing, because that can allow us to even get colleagues from there to work with us on the cases. Because of course here we have to kind of, be very clear within the remits of the confidentiality of the casework. But if we have an MOU, we facilitate to even make that move. So for me, it's really a geometry that I haven't seen before, at least not in the policy areas I worked in my many years in the Commission, that you really go European national in new ways, but also that you go within the Commission in a cross-DG, cross-directorate, cross-services approach, because you just need the expertise to get it right. So it's certainly not the final thing. There's also talk about we need to have a digital agency to deal with all that in the future. That debate will probably not go away. I think it would be far too early to engage in this now. But what we are seeing is the mushrooming of new concepts of interaction to really make meaningful impact on the basis of our rules.
Thank you. Thank you very much, Ms. Nikolay, and thank you also for practically introducing John Evans, our next speaker, as you alluded to the interaction between the European Commission and digital services coordinators under the Digital Services Act. So John, as the DSC for Ireland, you are in charge also of overseeing some of the largest platforms together with the European Commission. How is that cooperation taking shape, and the cooperation also with other sectoral regulators within Ireland? Which mechanisms have proven particularly useful, and which challenges have you encountered?
Thank you, and thank you, Renate, for the introduction. Is this working?
I think so.
I think so, okay. So what I'd like to talk about, sort of mirroring the approach that Renate has taken, is to talk a bit about the interaction of Commissioner Meán as a digital services coordinator at the European level, and then at the national level. So at the European level, as kind of Renate gave the example yesterday of Commissioner Meán being associated with the investigation of the Grok issue. That's an example, I think, of bilateral cooperation between relevant agencies, and I think you will see that mature as there are a number of digital services coordinators of establishment who have this shared role with the Commission for regulation of big platforms in their jurisdictions. I think you will see those kinds of actions become more frequent. This is our third one, I think. We were involved in an associated capacity again with two investigations, both of which were at TikTok actually. But now that this new one is the most recent. So you get that kind of bilateral cooperation. That formal mechanism is there under the Digital Services Act, but actually a lot of the work occurs at informal case team level. So we would have an X team, we'd have a TikTok team, and so on, and they will be in regular contact with the counterparts at the European Commission. And we find the European Commission had a bit of a head start on us, I would say. You know, they were involved in developing and negotiating the DSA, and were active on enforcement and supervision of the DSA before, say, Commissioner Meán arrived, and it's taken us some time to establish ourselves and so on. But now there's much more of an exchange of expertise between the two organisations, which works very well, I think, at a practical level. Then there's the cooperation through the Digital Services Board. So I think we met very shortly after the Digital Services Act became fully operational back in February 2024 as a board. We experimented, I would say, with the agenda, with the frequency of meetings, and that's matured. We now have a set of 8 working groups with work programs of their own, and that really encourages cooperation and, again, sharing of expertise among the different groups. There was a really example, and again, it comes from the area of minor protection, where last summer the Commission launched investigations into 4 of the large porn service providers that are VLOPs. At the same time, and this was the first for the Digital Services Board, there was an announcement of the coordinated action on porn. The reason being that it was important to address below threshold porn service providers at the same time as we were addressing the very large providers. Otherwise, if there is lax age gating, then users would, in particularly minors, can just move to below threshold services. So that's a really practical example of where a coordinated action is really important to deliver impact. A bit about the national cooperation level. I'm going to talk a little later about the Digital Regulators Group, which is made up of sort of core regulators in this space, like the data protection ourselves, the communications regulator, and the Competition and Consumer Protection Commission. But just to abstract a little bit away from that, we, as a digital services coordinator, kind of working at national level, the array of bodies that you need to link and build relationships with depends on which harm area you're thinking of. So, for example, in the electoral integrity space, we would, actually following the lead from the guidance provided by the European Commission on elections created just before the European elections last year, there is a facility or a strong suggestion there that digital services coordinators perform this coordinating function at national level with bodies involved in sort of the electoral integrity ecosystem. So that includes, electoral commissions, it includes fact-checking organisations, other civil society groups. In our case, when we convened meetings of this group, we would also have had our cybersecurity agency there, with kind of the foreign interference in elections hat on, our police service, and a good number of other related and interested agencies. So that was one harm area. And then just recently, because of this grok issue, we started flexing kind of relationships in that minor protection area. So that would include child protection agencies, Hotline, which is a service in Ireland which is supposed to facilitate the rapid takedown of CSAM and non-consensual image sharing, for example. So they were definitely someone we were reaching out to in this context. But again, on our police service again was part of that network. If you look at the fraud domain, there's a different group there again. We have done work with and certified our central bank as a trusted flagger under the Digital Services Act. We would be linking in with payment services networks in the Irish Banking Payment Services Organisation. And there are an array of other regulators in that space, including Competition and Consumer Protection Commission, the central bank with a different hat on, and a number of other agencies. So you can see as the harm areas multiply, the networks of relevant agencies kind of increase, and that's quite a bit to stay on top of. I would say rapid response is a key thing, and we've kind of realised that memorandums of understanding with these different agencies and protocols around when issues arise and require a joined up response quickly. But that's something that's developing. It's crystallizing as we speak. The system is crying out for it, actually. People, for example, with this grok thing last week or over since Christmas, the political and the kind of journalistic space was looking to who's responsible for this. Is it the European Commission? Is it Commission Meán? Is it the Data Protection Commissioner? Is it An Garda Síochána? And the truth was it's all of us. We're all responsible for that. What I was saying was, if you want to get the content down, contact Hotline. If you want to hold individuals responsible, you contact the police service. And if you want to hold the platforms accountable, you contact the regulators, and you flag the content always with the platforms themselves. That's a plug, but that's a simple message now, but it wasn't a simple message I had to hand at the beginning of the crisis. And I think it shows there's a lot of room for sort of simplifying to the rest of the world what we do, even if it's complicated in the back. Okay?
Thank you very much for that. Those interventions and simplification is definitely an ongoing topic of interest. And this brings me to Clarisse Girot, microphone's on.
Yeah.
Thank you very much. This one better? Thank you. Thank you very much. No, I was saying that simplification alluded to by John just a moment ago is definitely something or a topic that's on everybody's mind, including at the OECD. And this brings me to our next speaker, Clarisse Girot, who I would like to ask the following question. So this conversation on cooperation, regulatory intersection, and simplification is far from specific to digital and far from specific to Europe. So the OECD's work on general regulatory simplification and building regulatory systems that are proportionate, effective, and responsive shows similar trends, opportunities, and challenges, as well as some interesting insights. So what are some of the insights that you would like to share with us today? And thanks again for being here. Much appreciated.
Thank you, Brandon, and hello, everybody. Indeed, I'm sitting somehow in Andreas Hartel's chair, so I jumped in from another session into this one, so I still wear a bit of a privacy commissioner hat in a way, but I'm formerly a CNIL, a CNIL official, so that sticks very much. And at the same time, I now wear also a digital safety hat at the OECD, so I have to wear these two hats together, and I testify that it's not an easy one, but on a day-to-day basis now I have to combine this in my daily work. And in the OECD is about economic cooperation and development, so we look very much at the impact of regulation and how regulation can be made better, and that can obviously mean simplified regulation, but it also means primarily regulation, because regulation is not a bad thing. I think we have to keep repeating this over and over again. And obviously, the question is how to regulate well and how to harmonize, if not harmonize, combine in this case regulation with each other. It is indeed not specifically, it's not a topic that is specifically digital, and I think it's important to take a step back, and when selling the case for regulatory cooperation in digital at the national level in particular, because there's still a bit of marketing to be done sometimes, it's important to say there are many other areas like, I don't know, public procurement, utilities, you name it, where regulatory simplification and coordination are absolutely fundamental, and no clear solution has emerged yet. So that's the first message. So I think it's really important to put that in perspective. In many ways, the conversation we're having today is not totally new in the sense that regulatory cooperation between data protection authorities and other regulators have been happening for a very long time. And when I joined the CNIL in 2001, the first meetings I was having were actually with the central bank, with the health authorities, and we kept combining the regulations together. It's nothing new per se. I mean, now it's really on another scale because several regulators have to work together, more than two, which is particularly difficult. New regulators have seen the light of day, including digital safety regulators and now AI regulators. So that's really a bit on steroids, if that's the right way to put it. And this is really an area of work that is being looked at very closely for its economic impact. And to go back to some of the points that Kate made earlier, it is important to understand that this imperative of coordination is truly an imperative. Otherwise, we undermine the very purposes that each of these regulations seems to serve. And so it's not an option, it's really an obligation in a way. And the question obviously is how to do that, which is what we're doing today. Why is it important as well? We should not underestimate what it means for an economic player, for a big company in particular, to have not a united front, but at least a coherent set of regulators in front of them. It's a very important message to send. You're much stronger when you're aligned than when you go separate ways and try to combine your positions at the last minute, because then you're fragmented. And the legal certainty is also a core concern. You have to provide legal certainty. It's a duty in a way that you owe to the regulatees. So this is really what should guide us. In many ways, and I will pick up on that point a bit later, that does not necessarily lean, for me personally, I would say, in the direction of creating a super agency. I'm not sure that this is the solution that will provide utmost certainty right now, at least. Quick one on why we're looking at these issues at the OECD from a digital perspective. So we have a number of committees and working parties at the OECD that actually are basically comprised of members of regulatory networks. So we have a competition committee that President Lasserre knows very well. You walk into that room, you know what powers feel like. It's like all the heads of the competition authorities around the world is literally there. The digital safety regulators are increasingly meeting with us, although there's no dedicated working party there. The telecom regulators are there. Consumer protection, obviously privacy, and financial regulators, and many, many more. And the Financial Action Task Force, and you name it. Spontaneously, and this ecosystem is actually interesting because a lot of insights come from that. The issue of regulatory cooperation on digital actually landed on our desk at the privacy, the privacy desk, if you will. Why? Because data is cross-cutting, and the privacy data protection regulators, I think, have been the first to have been impacted so much by this need for regulatory cooperation. And I think this is also one of the learnings of Kate's experience at DRCF, that a lot of the use cases that came on your table, Kate, actually concerned 80%, I believe, the data protection authorities first. And then comes the time when you need to reach out to your colleagues to say, I think we should work together on this, or your colleague next door, in charge of the telecom community, if you will, comes in and say, the mandates of telecom regulators are getting seriously expanded, we should talk together. Well, the question is, who's in charge? And who does what? And is everybody really willing to cooperate? And our mandates align, and as your budget, does the money align? Because that's an important factor. Do you have the right staff? Do you have the energy? Does your direct manager support? And what we see is basically everybody supports, but someone has to do the work, and it happens. The first that gets the job is the first one that identified the need for the job. So we're working very hard on this. The big question for me is whether we need to formalize things further. And in this complex ecosystem, however complex, where we use to creating more expert groups and networks and working parties and whatnot, clearly the response today is no, let's work with what we have. There are tons of really interesting precedents at the national level, MOUs, obviously, a lot of OECD members, meaning member countries, we've asked them, basically, how do you deal with regulatory cooperation in digital in your country? We're still waiting for all the feedback, but you see that there is an array of experiences, like automatic redirecting of data breach notifications, or all sorts of integrated solutions like the Pérenne in France that are really valuable and should actually be enhanced more. And there could be a lot of insights there, also for the European Commission and the EDPS as you move forward on these plans.
Okay, thank you very much for this very enriching round of first interventions. I'd like to switch to the next round, but I would like to encourage everybody to be a little bit more succinct in your interventions, just so that we also have a chance for the audience members. A lot of expertise here as well, and I'm sure they have some interesting questions or contributions they would like to make. So let me start by turning back to John again. You talked a little bit about the coordination in the context of the DSA. You alluded also to the cooperation in the context of the Irish Digital Regulators Group. What are some of the experiences that you've had there and that you would like to share with us?
Okay, so in the interest of being brief, what I'll talk quickly about is kind of early days, middle days, and now kind of maturing a little bit. So early days, I would say you had these four regulators. They were seeing the juggernaut of different digital pieces of legislation coming down the track, and kind of anxiety about what's the institutional structure going to be to support these. It means a lot more resources at regulators to deal with them. Are we going to try and build on existing regulatory agencies? Are we going to create some new ones? So we got this group together, which was actually a subset of what we would have thought as more traditional economic regulators. So kind of they would have been principally utility regulators plus the competition authority. But now we would have had still telecommunications regulator, media regulator, and the Consumer Protection Commission, and then the data protection regulator, who is not an economic regulator. Okay, so this group is getting together. It's commencing a dialogue with government. So one of the good things that this group was able to achieve early on was to get a regular point of engagement with a cross-governmental group who had responsibility for negotiating and transposing pieces of digital legislation. There we got to talk about institutional structures, we got to talk about resources, and we got to talk about timelines and things like that. So that worked quite well. It got a bit of a boost, I would say, when we produced our first digital strategy as a country. And in there was a statement to the effect that we're going to invest in well-resourced, coherent digital regulation, including, and then mentioned the digital regulators group. So that was good. That gave the group a kind of a life, if you like, outside its own musings. Since then, we've focused on things like common issues like, skills development, capacity building. That's been a big one. Most of the conversations, though, have been more at strategic level with our heads. But now, as we kind of mature, we have kind of a modest, I would say, work program, an annual work program that we work through. The engagement is not purely at senior level at the moment, not at heads level. It's also a kind of operational level, so we're cooperating on some practical issues. There's sort of a recognition that while we have a lot of common interests, the overlaps tend to be bilateral. So supporting this has been kind of the creation of different bilateral cooperation agreements. So, for example, my agency plus the CCPC, because the CCPC is also a competent authority under the Digital Services Act, we have a cooperation agreement there. We also we have actually now a cooperation agreement with the Data Protection Commission. We have one with the Communications Regulator, and then the others have also kind of their own bilateral. So there's a network of bilateral cooperation agreements there. Challenges with those going forward are likely to be information sharing. So I would kind of share those similar sentiments to earlier. Kind of moving on now on how that structure is developing. I'd say maybe three things. One, we've kind of realized that there's probably a requirement to have some kind of a dedicated secretariat to help drive some of these issues on. So that's something we're working on at the moment. There's also a realization, I think, that to the point I was making earlier about communicating to the public what digital regulators do. So we did a small bit of cooperation where we produced kind of a very, very succinct one-pager which tried to give a fairly lay explanation of what the different regulators can do for them, and from a retail perspective where consumers should go. So I think that communications role is going to be very important, not just with respect to, say, individual citizens, consumers, but also to SMEs. I think that's something we're going to need to work on. And I think then the last thing where I think there's a lot of room for this kind of coordination is around horizon scanning, understanding technological and market changes and how that's going to change the landscape that we're all dealing with. I think there's a lot of room for fruitful kind of information and expertise sharing there.
Thank you very much, and also a great transition to back to Clarisse regarding the more international level and information sharing and best practice sharing that already takes place. I believe in late 2024 you organized a workshop with the International Network for Digital Regulation and Cooperation. I believe that's the same workshop that Kate alluded to earlier. What were some of the main takeaways from that workshop?
Thank you. Yeah, it was a fantastic experience, first of all. I think we actually showed that it was possible to bring networks of regulators and regulators of different countries actually into the same room. The room was not big enough. There are lots of regulators, lots of networks. It's a complex enterprise, but it was a first, I think, and it materialized the need and the appetite for collaboration. And I think these symbols matter very much more than a symbol. What struck me, again, was the amount of precedence and of, different ways of collaborating that were already happening, that were already there, but that nobody knew about, and that deserves to be better highlighted. The number of MOUs that are indeed concluded and growing, the lack of a proper legal basis to share information, and that really needs to be emphasized because it blocks collaboration, particularly at the enforcement level, obviously, between regulators, at the national level, but also in the cross-border level. And it's very often, the cases are very often cross-border and cross-sectoral at the same time. And if, by the same token, we could give the possibility, the legal authority for data protection authorities to share information among each other, that will also be a plus. I'll be brief because there are many takeaways. One that really stuck with me, and I think this is where we'll try to provide support, is the importance of putting forward precedents, successful precedents of cooperation, concrete decisions where the regulators have come together and issued a common position, and that happens in many countries, way beyond the EU, and within the OECD membership, but also beyond. And that is actually great help because it's a reference for regulators dealing with similar cases or even the same cases, and to rely on, even if at the end the solutions retained will be slightly different. Meaning, really, my message is build on what you have and support the national regulators in terms of budget, in terms of staff, helps them retain staff, and then at the national level find solutions exactly like the PEREN, like President Lasserre was mentioning earlier, share expertise, develop solutions for shared expertise and shared functions that are still very light touch so that national authorities can function in symbiosis.
Okay, thank you very much. And in light of your remarks, I'll switch the order just a little bit because you emphasize building on what you have, right? Building on what's already in place. So my next question is for Mr. Lasserre. How do you think we can or should enhance cross-regulatory cooperation at the European level? We've already heard several times a reference to the DMA high-level group. That specific format, do you think it should be expanded, reformed? Do we need another setting entirely? What are your thoughts?
Thank you very much. Of course, the idea given by Alexandre de Stels this morning about the super European agency is seductive on the paper, but we must be very fair. The path will be very long, very lengthy, very difficult, with a lot of political hurdles and time. So we have to work maybe on less ambitious targets. And to be very frank, the initiative taken by the DPS of proposing this digital clearinghouse is something excellent. And the high-level group, the DMA high-level group, the chance to be a member of, and we had a recent meeting, is fantastic. It's a really interesting as an experience to gather people from data protection agencies, competition agencies, media agencies, electronic communication agencies, consumer protection agencies, and what is interesting, we talked to the Commission, we exchange views between different communities and inside every community, and we agree. Because the position was consensual. Even if we have mandates which are different, if we have aims which are different, we converge on the product delivered by this high-level group. So that's something we must really think about. Maybe the question is how we can enlarge the experience. Is it something we could use, for example, for artificial intelligence? That's an interesting point. My view is that forums are really irrepressible, something absolutely fundamental, provided we talk not only about strategic initiative or concepts or about the way we put forward new legislation or we adapt existing legislation, but they are useful if they talk about enforcement. Because, and maybe I'm immodest saying that, but from my 12 years experience as chair of the competition agency in France, what I know is that we progress by doing cases. It's the way we learn. It's by doing cases, and it is the same with the Data Protection Agency. So if that coordination groups, talk about strategy, legislation, and are not able, for legal reasons I understand, how we collect evidence, how we share information, how we pursue maybe common cases, we lack expertise and we lack opportunities to progress together. So, of course, there are legal issues to contemplate and to solve, but I think such groups, without a clear mandate on enforcement, miss, I would say, good opportunities. The last remark I would like to make is the following. In my report I published last year, there is what I call the 15th proposal, and I would like exactly like Alexander did this morning, maybe touch upon a point. As an observer, I see a lot of regulations, European regulations, reforming regulation in many aspects, media, financial services, energy, telecom, data protection, competition, and so on. And what strikes me is that each time there is such a common regulation, and the question of how this regulation will be implemented by the European Commission, but by national regulators as well, there is a question about a network of what I call European regulators. And what I see is the multiplication of European regulatory networks, which all have been created by specific regulation, but without any, I will use a French term, vision d'ensemble, strategic thinking about what is the best way to have an effective and consistent network. As a formal member of the European Competition Network, the criteria to allocate cases between the European Commission and national regulators and between national agencies was a very blurred one, a very vaguely worded criteria. The best place agency had the right to claim the case. In the media regulation or the data protection regulation, it's the country of origin criteria. I respect, of course, the political incentives to choose such or such criteria. It's a question of policy, and of each choice is legitimate. But we have never assessed the weaknesses and the successes of each network. We have not exported the successes of a network to other ones. They don't talk to each other. And I think what we need maybe today is a strategic thinking about the good governance of regulatory European networks, how we allocate cases effectively, and how we create incentive to work together, but in a way which at the end will protect the European businesses and users. So that's my last idea, and I would like to work in the next month about maybe some cartography, some comparison between the networks and making proposals, but very humble ones, of course.
Thank you very much. And again, a seamless transition. My job is really easy. My next question and final question before opening it up to questions from the audience is again to Ms. Nikolay. A recent Commission report assessed the interplay between the Digital Services Act and other laws, acknowledging the complexity. The report noted a need for stronger inter-authority coordination, joint guidance, and possibly a one-stop shop mechanism for cross-border enforcement. What are some of the concrete ideas that the Commission has in mind to promote such cooperation?
Yeah, this Article 91 report was an obligation that we had under the DSA to kind of report on how the DSA sits with neighboring rights, and we looked at more than 50 legislative kind of pieces, so that shows you the complexity. It wasn't necessarily a report to conclude already so much. It was more of a descriptive nature. But kind of building on what we also heard, I want to highlight a couple of things. This commission really means it when we speak about simplification. It's a different kind of, approach to this aspect compared to previous attempts because it's a top-down approach. It's in every mission letter of every commissioner, of every executive vice president. We launched, when we did our digital omnibus proposal in November, also the digital fitness check. So this is a very broad consultation that I kind of recommend also, Mr. President, to kind of read and maybe contribute to it, which looks at, for instance, also the governance structures that we build. We will take time to kind of deal with this fitness check, but it can certainly also enlighten us in looking at what governance structures might kind of evolve. When you take into this kind of, debate also the important contributions that we got in the run-up to this commission, so in the transition from the previous commission to this one around the European Parliament elections, all the important wise men reports, Draghi, Letta, Niinistö. Then you had, for instance, a very, very strong, all of them dealing with resilience, competitiveness, and kind of, a single market. And you had, especially in the Letta report, if I remember it well, a very clear and good description of, how the governance structure has evolved. And I think, looking at it here, I sometimes say, because I'm dealing with both. I was involved in the GDPR. We found a certain governance structure, which is the classical decentralized one, with some kind of one-stop shop, and we know the details. But it's still a classical decentralized kind of, enforcement structure. And when you look at the implementation reports, there's also an issue around fragmentation and effective implementation because of that. Then if you look at, I sometimes say, the second generation of digital rulemaking, which is AI Act, DSA, we found a different way. It's more of a parallel structure. We acknowledge that there are some issues that should be dealt with at the European level, because of the size of the players in the context of the DSA, VELOPS compared to others, or in the AI Act, now also with the recent digital omnibus that we did, to even bring the general purpose AI more into the remit of the European Commission to allow a more systemic and coherent approach on this very important technological development that has so many read-acrosses also with the DSA, the DMA, and also the GDPR. So you see a development on this, And it's an interesting development because you could argue, if you look at the interinstitutional kind of balance that we also always have to bear in mind when building the European integration model further, there's always an interinstitutional balance to be kept. I'm never of the view that everything should be kind of in Brussels. We are far too distant from the citizens, from the business needs. There has to be a balance. But what was interesting, whereas, I don't know whether everybody knows that, whereas in the GDPR proposal from the Commission, we had foreseen a more centralized kind of governance structure, and it was kind of pushed away by the member states at the time. When we proposed the DSA, we did not dare proposing a more centralized structure, and it was pushed by the member states at the time. So this is certainly also a reflection of how we look at internal market, effective implementation of our rules in the internal market, which is the biggest asset that we have. So for me, this is one of the big questions for the future. That's why I said also in my first intervention, we have created multiple kind of structures. I deal with it. I'm in the high-level group. I chair the DSA board. I have plenty of roles in my senior official role in DG Connect. I happily play these roles, but I also see that Commissioner Meán is very well resourced. Probably you could still use more, but Ireland has taken conscious choices. But when you look at the 27, there's a lot to field: an AI board, a DSA board, a kind of a data protection board, and you name it. And, so I think that's why, we are in this kind of process where on the one hand, we know, because also of the geopolitical context, we need to be efficient. We need to kind of, be effective in what we do, show that what we do has impact. and is actually kind of leading us forward. But on the other hand, how to do this best, what to kind of leave at the European level, how to have effective enforcement structures, how to have effective and new and modern cooperation structures, I think these are really important issues. On your issue on working on cases, I mean, I'm discovering the competition world because of the high-level group. And of course, here you have decades of casework. This is just different in where we are on the DMA or on the DSA or even on the GDPR, you know. And I think that's something where I have high hopes in what we design with the individual digital service coordinators in cooperation on cases individually or in cooperation with other commission services on individual cases, whether, you know, when it's more in the territory of CSAM, then we bring in the home colleagues, for instance, and things like that. I believe more in that. It has to be built up from scratch. You know, we just had one non-compliance decision on DSA. We have 2 non-compliance decisions on the DMA. It's early days, you know. We're in year 2 of the effective implementation of these rules. So that's why I think, you know, work together in cases, I think will evolve. But I think we have to give us also a little bit of time, you know, to build the credibility of the system. And this is my last remark, against some odds out there. You know, we all here speak about how relevant regulatory cooperation is, how relevant regulation is, but there's another debate out there that kind of thinks that this regulation is not good and should go away and should not even be applied. We withstand that, but I think that's just a context also talking about international cooperation that is quite complex to deal with in the current times.
Thank you very much to all the panelists, and definitely already a lot of very interesting insights. I would like to turn to the members, participants in the audience, to get a sense of what your thoughts are, and if you have any specific questions that you would like to put to these esteemed panelists. Please. If you could just also briefly introduce yourself and your affiliation, that would be great. Thanks.
Yes, hello. My name is Nathalie Laneret. I'm the head of public policy at Criteo. Criteo is a French AI champion in AdTech. So, I mean, maybe we'd like to go back to what Professor Strehl mentioned early this morning about the need to have common guidelines and doctrine. But I'm happy to believe that we live in a perfect world where everybody can agree, but sometimes there are real conflict of laws. So how do we can overcome this conflict of laws in a pragmatic way and to have courageous doctrine whereby, and sorry about this, but the guardian of each temple will actually agree to a compromise? And I just want to cite as an example the draft guidelines on DMA and GDPR, which in their current form, they are still a draft. I read them, and apologies for this, but more as a compilation, as a piling up of the different views of, on one side, the EDPB, on the other side of the Commission, but I don't see any type of, again, compromise here. So how do we overcome this? What do you think about, and this may sound as a crazy idea, but let's be creative, of having maybe an exchange program between different regulators so that they really get to understand how other regulators think and work to actually be able to more understand each other and each other's position? Thank you.
Thank you very much. Is there anybody who would particularly like to react to this suggestion, provocation, idea? Clarisse, go ahead.
I will obviously not comment on the guidelines. That's not within my remit. But if you look at the kind of cooperation activities that take place between regulators, secondments, definitely, sharing of staff, regular meetings, I mean, these things happen. So, you know, I think it's not such a crazy idea.
Mr. Lasserre, you would like to compliment?
There is one thing I believe is important. You know, competition derives from the fact that there is a stimulation of businesses, of companies to differentiate their products in order to appear as better than other ones seen from the user. And what I see as a convergent aim of regulators is to encourage a market where data protection and protection of privacy would be a competitive parameter. I mean the fact that companies would differentiate their products or the services not only on price or on quality, but on the intensity with which they protect the privacy of their users. That would be something I think I would encourage, to see privacy as a competitive parameter of differentiation and of competition between businesses. And in that respect, I would see both regulations as very convergent.
You want to come in, John?
I just want to comment on the guidelines. I mean, this is work in progress, and I think the fact that we are working on that is good. I think it's also, I'm saying that now because we have, as you might know, done a digital omnibus, where we have touched some of the GDPR. So we have, for the first time, opened the GDPR. Not as a heart surgery, not as the principles, but, you know, to kind of bring out a little bit more of a single market and kind of pro-innovation aspect, and kind of lightening some of the heavy procedures. So why I'm saying that? Because I think GDPR will turn 10 this year. And it's probably also a moment to kind of, you know, look at the GDPR experience from that perspective, you know. So how far have we come in kind of, you know, fulfilling the promise that this is a single market aspect? It's no longer a directive, it's a regulation that should bring kind of, you know, a common framework for the single market. And when we negotiated, and I was part of it, it was also certainly a pro-innovation kind of, you know, being neutral on technology. And I think we are in the middle of this, whether that's in the context of the digital omnibus, whether that's in the context of the guidelines. And then the last point I would make on that, Article 5.2 DMA does not mirror GDPR. And that's also an important aspect, you know, when we're talking about the guidelines. So I think this is a very important work progress. It's not perfect. We are not where we should be, and certainly also not where we will be in 2 to 3 years' time. But the fact that we are talking, the fact that we are putting that on paper in a context where everything is moving, including how we look at GDPR, not at the main principles, but at how it works in practice. Also that is an important kind of reflection in this. Optimizing the impact of our regulatory framework, you know, even though it's built on a fundamental right.
Thank you very much. John, did you want to come in too?
Yeah, maybe I'd just like to give an example where I thought it worked well, where we were trying to balance kind of different fundamental rights. So this comes in thinking of minor protection and privacy. So when engaging online, whether or not different services require age gating or not, the European Commission, the Digital Services Board produced last summer guidelines in Article 28 of the DSA, which is the one which deals with minor protection. And in there's a lot of good work on what good age gating looks like. The Data Protection Board was very involved in that process, provided papers, engaged in discussions, and we think the solutions that are provided for in that guidance are privacy protecting solutions. So I think that's a really good example of where, I'm sure this debate won't go away, but where we find a practical way forward.
Thank you very much. I think we have time for at least one more. I see, Laureline, please go ahead. Now we can.
It's okay. Yeah. Laureline Root, Microsoft. So thanks for the interesting panel. I agree with everything basically that has been said, also underneath the for regulation. And it is heartwarming to see a discussion on this ongoing, because as Clarisse has said, it's really important for companies. It is also heartwarming to see the work from the EDPS or the fact that the English example is getting babies, as Alexandra has said it. But I was a bit surprised to see in the simplification package, which we also welcome, by the way, to see relatively little attention to this question so far. Because even if we simplify laws and we don't simplify the enforcement or make it more consistent, we will get to the same difficulties in a while. And I heard you, Renate, say that it's early days, but it is really key to start early on, we believe. So, and also in terms of the European example, if Europe can show that it can be pragmatic and consistent about its enforcement, maybe that is also a reason to defend its regulations.
I think that was a question for Renate.
Yeah. So let me be clear. I mean, this digital package of November is an omnibus. This is a specific vehicle that we have invented in the simplification policy that follows a different approach from normal kind of, legislative work. So for me, believing in better regulation and really doing full impact assessment when you're playing with, for instance, governance structures, I would never have touched the governance structure of, for instance, GDPR in an omnibus. No way, because you really need to kind of prepare that well through a proper impact assessment. This doesn't mean that our digital omnibus is a shooting out of the hip. We have consulted, we had implementation dialogues, we had focal point kind of consultations. But we went for the low-hanging fruit on cyber, on AI, on data, that we wanted to kind of, show as a kind of a first wave of simplification. That's why I've stressed the digital fitness check. That's the real work on simplification that I hope we will still be able to kind of develop in this mandate. And that would then, of course, have to be followed by proper kind of preparatory work on proper regulatory interventions if we so decide. But it would just have been too far-reaching. I was in Liebe yesterday, and already this omnibus is being criticized for not having gone through the full impact assessment. Imagine we had done something on governance, and rightly so. People would have argued, why haven't you followed the full kind of set of better regulation tools that you have imposed yourself for your work? And I think with what we have put on the omnibus, we can very well justify that, because these are clear demands, and old kind of issues that needed clarification and adjustments, but not a full-fledged kind of, answer to the debate that we are having here today to deal with the governance structures of the future. That requires a totally different set of preparatory work.
Thank you very much for that, and those of you sticking around tomorrow will also have a chance to debate a lot further on the digital omnibus. I would like to keep with time and thank very much our excellent speakers for their interventions today. Please join me in giving them a round of applause. And let's have lunch and meet back in this room in about 1 hour. Thank you very much.